We'll hear argument next in case 22-611, Linke versus Freed. Mr. Keatum.
Mr. Chief Justice, and may it please the Court. The dialogue between public officials and their constituents is fundamental to our democracy. Much of that conversation now takes place online, with social media platforms serving as the new town square, where public officials provide important information about what they're doing on the public's behalf and soliciting comments in return. While public officials retain First Amendment rights, use of a private social media account does not immunize an official's conduct from First Amendment or constitutional scrutiny. Under our test for state action, a public official who creates a channel for communicating with constituents about in-office conduct and then blocks a user from that channel must abide by the Constitution. This test, which focuses on how the public official is using and purporting to use that account, is consistent with this Court's precedent, under which a public official who purports to act in that capacity is a state actor. It also accords with Section 1983 and the original understanding of what it means to act under color of law. The Sixth Circuit's duty and authority test, by contrast, would provide ready means for public officials to evade the Constitution. Here, for instance, it would mean that the city manager would be free to block from his Facebook page any constituent who is a member of a disfavored race, religion, or political group, free from constitutional constraint. Our test avoids that result while still leaving ample room for public officials to communicate in their personal capacities. I welcome the Court's questions.
Would you also win under the doing their jobs test?
Yes, we absolutely would, in part because, as has been pointed out, part of the job of any high-ranking executive official, and the city manager is essentially just under the mayor in terms of being high up in city government. Part of that job is telling people about what you're doing. And what Mr. Freed was doing with his Facebook account, sometimes multiple times a day, was informing the citizens about what he, as city manager, in his role as city manager, was doing for the town, and then communicating directly with constituents about that, sometimes answering their questions about the scope of his orders.
But Ms. Carlin made the point that there are only 3 instances on the website there in the last case that were personal. In this case, just going through the joint appendix, there's quite a bit that is personal. So how would you just factually distinguish that or emphasize the fact that
Sure.
the personal here does not override the official?
So there were certainly a lot more personal posts, although the ratio of job-related posts to personal posts changed dramatically at the start of the pandemic, as you would expect, because a lot of the services and the way that he was doing his job migrated online. I think once you've established a channel for communicating with constituents about your job, I don't think also posting sometimes about your family is going to undo that. Although if what you're complaining about in a specific case is having a comment on a personal post deleted, obviously that would change the equation.
Does it matter if you've established this channel ahead of time and before you became a public official? I mean, you sort of suggested that it had to do with the purpose of the account.
So I think you would look at what you were doing with the page beforehand, or you could, I suppose, but I think it's fairly clear that Mr. Freed wasn't talking about the job of the city manager before he actually became city manager. He wasn't posting about directives that he himself issued until
Right, but I guess I'm asking, does it matter whether or not he opens up a new page once he becomes the city manager and begins conversing in the way that we're talking about, or alternatively, he had this page before he became city manager. It had all of his personal information and, you know, pictures of his kids and whatnot, and he just added to the stream of conversation.
So I think that's something that you would look at. Obviously, it would be a factor, but there were a lot of things that changed when he became city manager, not just the content of the posts, but presumably he also didn't list as his website on the page this official city address. He didn't use the community comments at porthuron.org as his email address. There were a number of things that changed by virtue of the fact that he was starting to use this in his capacity as the city manager of the town.
Would it have mattered to you if he had a disclaimer on it?
So I think It probably wouldn't get you back over the line into personal use, in part because of the way that he was using it to make certain announcements and issue directives, information that you wouldn't necessarily be able to get anywhere else. And certainly there was no other place that you could go to interact with the city manager. Now, it would have, I think, been something that they could argue that he was using this in a personal capacity, but I think the disclaimer would have been substantially overridden by the way he was actually using the page.
Just to be clear, if the page had not been created until he became city manager, would the case come out the same way? Should it come out the same way in your view?
It would, although perhaps it would be even clearer than it already is.
It would be, okay. What if 95% of the posts are personal and 5% of the posts involve a discussion of his work?
So it would obviously be a more difficult argument for us to make, but I would still be here certainly as my client's attorney telling you, look, if there's only one place to go to interact with the city manager about directives that he himself had issued, the fact that he posts a lot about cats or whatever personal thing he wants to post about, that doesn't change the fact that if you get blocked off from that page, you're suddenly losing access to a lot of information.
So if it's entirely personal, but once he slips and he talks about his work, that changes it?
I think it does, because it's not really being established as a channel of communication. It's a little bit like running into someone at the grocery store where maybe they let slip some information about the way the government is working. That doesn't mean that they are going to the grocery store in order to interact with constituents. But you could obviously change the hypothetical where they say, I'm going to hold office hours every Friday in the grocery store for an hour to talk with citizens about pending legislation and what I'm intending to do.
So I'm not sure about what the line that you're drawing. You said if it's 5% official, 5% work-related, then it's state action. But if it's like 1%, 1/2 of 1%, it's not? Is that what you're saying?
So it's not a quantitative test, it's qualitative, but the quality that you're going for is whether you've established it as a channel of communication. And I thought I understood your hypothetical as essentially just one thing you said one time. There's no understanding or expectation that you're using this as an ongoing channel of communicating with constituents.